I have a number of amendments in on this bill, not just to this section but to a range of sections, and they all essentially seek to do the same thing. And it relates, Minister, to an issue that I raised at second stage in this bill. This bill is tremendously important. Nobody would dispute that. It puts in place a streamline that I think is welcome, and it implements the provisions of the 5th directive from the European Union, which is important as well as legally obligatory. However, this is the third bill in this vein. So we had an initial bill in 2010, it was amended in 2018, it's being amended now again, with the result that the final bill that is passed now will essentially amend the 2010 Act, and it will be an extremely cumbersome instrument because anybody reading it must essentially refer to the three bills simultaneously to ascertain exactly what the Act that we pass in the Houses under this guise will say, and how exactly it will implement the directive. Now, again, I understand why that happens, and there is a practice in these Houses that when we amend legislation, we put into the bill that's amending it exactly the provision that's being changed and how it's being changed. What we don't do is list the new section and how the new section has been changed, or the new subsection even, with the result that you might just have a single line in an amending bill. And the point that I made at second stage is that that makes it nigh impossible for an ordinary citizen to read the legislation, or indeed any non-lawyer, and I suspect many lawyers as well. It makes it very difficult for them to read the legislation and to understand the legislation without significant study and effort. So what I've done in this amendment is, in relation to the interpretation section of the 2010 Act, which is being amended in section 2 of this bill, I've simply set out what the interpretation, section 2 of the 2010 Act would look like if the amendment of this bill were put in place, and of course we know that it will be, or we expect that it will be. So I've essentially restated the section 2 of the 2010 Act as it will look after this legislation passes. I should say that I'm absolutely indebted to the work done by the Law Reform Commission in this regard. Members will be aware, because I've mentioned it in this House before, the Law Reform Commission carries out a hugely important civic function by putting together consolidated or acts where we have amending legislation. So where there's a sequence of amending legislation, the Law Reform Commission has a project that it undertakes and makes freely available online the Consolidated Act as amended. So, and they will show each step of the way through why it's changed, how it's changed, what operation has been done to change the bill. And that's very valuable, I think, particularly for senators and TDs, but also for members of the public to do exactly what I'm talking about here. And the argument that I'm making is we should be doing this all the time. We should be going out of our way to make legislation accessible for everyone, accessible for people who read the legislation and have to live by the terms of the legislation. And there's lots of issues in this, and I'm not even talking about any particular issue. I'm merely talking about the accessibility and legibility of the legislation that is passed by these Houses. So in the series of amendments, and I'm only going to speak on this one because I don't want to delay the House's time on it, the series of amendments I've put in here are to show how that can be done. Now, I'm one person, I do it myself, and I prepared it in time for this committee stage. The department, with its vast resources, and I know, Minister, the armies of people you have at your beck and call every day, could give effect to this relatively easily, but particularly where the Law Reform Commission has already done the work. And as I say, it didn't take very much for me to go onto the Law Reform Commission website, look at their work, and transfer that into amendments to this bill. It's easy to do, it can be done. Now, I understand that the department is reluctant to do it for a whole range of reasons, and I understand there are things like, for example, the loss of the legislative history. One of the things that we can look at in this House, for example, since I became a senator, so in the last year, we have twice amended the Health Act 1947, for example, with 2 successive bills. And it's very easy to go back and therefore trace exactly how the Health Act has changed since the 1940s. But there is another way to do that. We don't have to record that in successive amending bills. We can simply have, as we used to have the chronological tables, for example, on the statute book that's available online, we could easily create a section of that that shows the progress of a piece of legislation or how it's changed, when it's changed, etc. And it could be linked into the debates that are recorded again freely on the Oireachtas website. So I don't really accept that as an argument why we aren't doing this. There is an administrative argument, and I recognise this at second stage. It clearly creates an administrative burden on the department, on presumably the Office of the Attorney General, who do the technical amendments and drafting in relation to this, and the generation of paper, etc. I can see how that might be a problem, but we must balance whether that problem or that difficulty outweighs the benefit of having legislation that is much more accessible to members of the public. And I'm sure there are other administrative problems, but the fundamental reason I put down this amendment and the succeeding amendments are we need to send some kind, or put down some kind of marker to say to people, we no longer want to have a raft of legislation. And there are particular areas where it is very, very obvious. Road traffic legislation is a particular example of it. But we did go to the stage, for example, in the 1990s of consolidating social welfare legislation. There are lots of other steps that we could take, but there are particular pieces of legislation and streams of legislation that are largely inaccessible to members of the public because of the way we are passing them in these houses. And by putting down these amendments, I'm trying to say to you, Minister, and to the government and to your department and the people within government who are responsible for drafting legislation, that we should be taking steps to make legislation more legible and more accessible to the public and to everyone else. And that's the reason I don't propose to push the amendment, however, because it is a function that I'm putting it down really to have an opportunity to raise the point with the Minister.